Christa, they made a nuanced argument a little later in the day that basically involved the type of testimony that these witnesses can give. One particular witness, they wanted to talk about the aftermath of the shooting and what they had to go through to get better. And they objected to that, saying that that's not relevant to proving one of the aggravating factors, and saying, you know, if the aggravating factors are a number of them, this particular one being the heinous nature of the crime, and that's not included. The state fired back and said, you know what, this is about the weight of these aggravating factors, and that type of information about what they had to do to get better and recover from these shootings goes to the weight. And this jury has to consider the mitigating factors versus the aggravating factors. And the judge ultimately decided that that was the way it was going to go. Your thoughts on that? I thought it was an interesting, nuanced argument based on the statute, but at the end of the day, I think all of that should be included.
Yeah, it was a nuanced argument, and I think it's a close call. I think the judge is making some close calls here, and she is allowing more evidence in. I question some of that because you don't want to, you want it to be a tight appeal, right? You don't want anything to be disturbed on appeal. So I do question some of it coming in, but the very nature of all of this cumulative evidence has to come in. It would have came in if there would have been a trial and the jury would have been able to hear all of it. So this is now that opportunity for this jury to hear every single victim tell what happened to them, which they would have heard if there wasn't a plea. So I think that causes that cumulative argument to fail, because this jury needs to consider all of that in determining what mitigating factors are there and what are not.